The details of the meetings are to be kept in the form of the minutes of the meetings as prescribed under the section and the rules appended, and the companies are required to keep and maintain true and fair records of the proceedings of the meetings in the form of minutes in accordance with the Act, rules and the secretarial standards as well. Minutes must be signed by the chairman of the meeting within 30 days of the conclusion of such meeting. The minutes have the evidentiary value for the proceedings which have taken place at the meetings and thereby recorded in such minutes. Now we move on to the meetings of the board of directors, wherein board of directors for transacting day-to-day business activities of the company are required to meet at time intervals as prescribed under the provisions. Section 173 requires that a board meeting shall be held within 30 days of the incorporation of the company. That means within 30 days of incorporation of the company, the board of directors are required to meet and hold and convene a board meeting. Thereafter, at least 4 board meetings must be held every year with not more than 120 days gap between 2 successive board meetings. So usually each quarter must have meeting of board of directors. Such board of director meetings can be either held in person or through video conferencing or any other audio visual means. That means even the directors who are not personally present at the meeting can take part in the proceedings of the meeting through the availability of these audio, visual and video conferencing means. However, there are certain matters which cannot be dealt through the video conferencing mode. The notice of all such director meetings must be sent to all the directors at least 7 days prior to the date of the meetings. However, if all the directors agree to a shorter notice than 7 days as prescribed, they can go ahead with a shorter notice as well for calling such meetings. Then there are certain meetings which are held of the committees which are constituted of the board of directors, like the CSR committee, which is required for taking decisions as regards the CSR policy of a company. It shall comprise, such committees usually comprise of minimum 3 of the directors, of one happens to be the independent director. Such CSR committee meetings have to be held at regular intervals so that they can deliberate upon the CSR policy of the company. Further, there are the audit committee meetings, wherein audit committee happens to be a mandatory committee in case of a listed company, and also prescribed classes of public company which require to set up this audit committee for the requirement of seeing the remuneration and taking decisions as regards the auditors of the company, and in such cases the meetings can be held for such audit committee members. Then there are nomination and remuneration committee, which usually take decision as regards the reasonableness and sufficiency of the level of remuneration which is decided for the board of directors, whether it is adequate or not, and also they are required to hold meetings at regular intervals. Besides these, there are other meetings like class meetings and creditor meetings. First, we will begin with the class meetings. These are those company meetings which are held for a particular section of members only. Only those members which are holding particular shares of a particular class are required to attend and vote at the meetings to pass such resolutions which become binding upon them. Such meetings are held only when the rights of such members are to be altered or affected. For instance, under section 48 of the Act, wherein the variation of shareholder rights can take place, so such class of members are only required to hold such to attend such meeting and pass the resolutions by passing a special resolution to this effect. Then there are creditors meetings. These type of meetings are held for both secured and unsecured creditors, are usually held, such creditor meetings are held at the time of approving the scheme of mergers as required under section 232 of the Companies Act 2013, or at the time, and also at the time of company when it is going into voluntary winding up. Then also the the meeting of the creditors are to be held and convened. Summing up, in this module on company meetings, we have covered the concept of meetings and their significance for the conduct of business in a company in an orderly manner. Various kind of company meetings like the member meetings, director meetings, class meetings and creditors meetings. Relevance of all such kinds of meetings for the stakeholders of the companies. The procedural compliances as laid down under the present Act and the rules appended thereto are discussed, for which are required for convening a valid meeting for purposes of taking valid and binding decisions of the company. Thank you.